Reports are coming out that the decision on whether Fani Willis will be recused and removed from the case is imminent. Imminent being you cannot even get on the Fulton County Superior Court website right now to track down an order. So let me tell you how we're going to handle this today, because we just were talking about this. All hands are staying on deck even when we're off the air, because if it comes out, we're going to go live on, we don't know which platforms yet, but I'm assuming it'll be on every platform to let you know exactly what happened. So that's pending. At the same time, there is a motion to dismiss that is pending in South Florida on the documents case. And we're going to get into that one as well, because on that one, Andy, the motion to let's explain what the motion to dismiss is in federal court.
A defendant can file a motion to dismiss an indictment on the basis that it does not state a crime. And what President Trump's lawyers have done in the Southern District of Florida before Judge Cannon there in the West Palm Beach Division, although she sits in Fort Pierce up the coast, is they have filed a motion to dismiss the indictment based upon the Presidential Records Act. And what they're simply saying is this: while he was president, the president had the right to determine whether records were personal or whether they were presidential records, and he designated them as personal records. The National Archives has no right to control or seize them, and no criminal proceeding can be brought. The motion argues that judicial review, that is review of a court, by a court, of President Trump's decision to designate materials as his personal records is barred, prevented.
A motion to dismiss, we can do this quickly. If it's granted, is that it for now?
It can be appealed.
So it's an appealable order?
Yes, because it's a final order. It would stay everything, but the government can then appeal that to the Court of Appeals.
If we focus initially on the Florida case, President Trump argues that he issued affirmative designations with respect to certain records and documents, and suggested that he had the authority to transport those documents to his Florida residence at his sole discretion. So one of the big issues, I think, at the end of the day, not to get too deeply into the weeds, is the concept of separation of powers. As president, as the executive, he arguably had sole discretion with respect to certain documents, and he moved those documents. The documents were moved in an open and obvious, non-surreptitious way. And so I think the president may indeed be on sound constitutional grounds. Also, it's important to keep in mind that the Presidential Records Act, its recovery mechanism, is arguably exclusively civil in nature. And so one of the things that President Trump has done in bringing this motion is to argue that we have precedent with respect to President Clinton. Yep. And President Clinton made this argument successfully, yes, apparently, many decades ago.
For your defense counsel, you read the indictment and you see if there's anything that you can dismiss the indictment for. And what they've done in this case is they've gone to Rule 12 of the Federal Rules of Criminal Procedure, and they basically are saying, you haven't pled a crime. There's no crime here. Even if you assume that everything that you say in the indictment is true, still the government has not pled a crime. Why? Because, as Professor Hutchison said, the president designated the documents as personal, and the National Archives has no right to control or seize them, and no criminal proceeding can be brought. The motion, and I've read it, argues that judicial review by a court of the president's decision to designate them is barred. Can't do it based on separation of powers, and courts don't have any authority to review even whether that classification decision was made properly or not. That's up to the president. And if you want your records back, the way you get them is going in court and you file a civil action for recovery of the materials, but it certainly isn't criminal.
With a two-tiered form of justice, we basically designate criminal charges on the basis of political preferences. So with respect to Donald Trump, many of his opponents essentially see him as a threat to democracy. And so they are basically trying to deploy any means necessary to prevent him from running for office. And so we should ignore, in many cases, the so-called underlying criminal issue. What's the purpose? The purpose is to prevent Donald Trump from running successfully for president in 2024. Meanwhile, the individuals that claim that Donald Trump is a threat to democracy, they are quite willing to excuse the behavior of Mr. Biden and perhaps the behavior of his son. And it's also important to keep in mind what a precedent has shown. We did not charge Bill Clinton criminally with respect to misusing classified documents, and we did not charge many of Clinton's officials, the individuals that served in his administration, with criminal charges. I think it's a mistake to charge anyone, whether it's Biden or Donald Trump.
I think both of these cases, the case against Joe Biden, although distinguishable because he was not the president, he was the vice president. And the vice president does not have the authority to declassify documents. A president has the authority to do it on his own initiative. That's because of his article of power as commander-in-chief. He could just do it. That's his right and ability. But in either case, I think this would have been a big mistake bringing a criminal case. I want to talk about this Fani Willis situation for a moment. That's that would be the biggest order to come down. Motion to dismiss, of course, being granted would be huge too, but you're not going to get that today. But either today or tomorrow, we're going to get the order in the motion to disqualify any in Georgia, because you practice in Georgia as I did. If that motion is granted to have her removed, what is the impact then on the case? Everything's held, right?
If she is removed from the case,
yes,
then there will have to be another prosecutor appointed to determine whether or not to proceed with the case. And that new prosecutor, whoever that might be, could be a DA who is already a DA in Georgia and is appointed DA pro tem. It could be a special prosecutor. But at that point, that prosecutor has to make a decision, and that decision is whether to pursue this case.
If the Fani Willis order comes out on the disqualification issue from Judge McAfee, we're going to go live. And we will also, of course, get it up on all of our platforms. So you'll have the information. I'm sure we'll get an email out as well. If that happens today, the expectation is it's imminent. Imminent could be 10 minutes. It could be 10 hours. It could be, I don't think it'll be later than tomorrow. So anyway, so we're monitoring that and working on that, and we'll keep you posted on the developments there.